This is my second hearing in Levy County Courts with Judge Craig DeThomasis against LIEnette Preston, if that's even her legal name. And I've already been lied about, straight-faced, from the judge, declaring that I have to provide proof that I was standing in a hearing in court in Ohio. Nobody said I was going to a hearing. It was said I had to fly to Ohio to take care of things for a hearing. Now this judge is going to take away my First Amendment right of speech. And yours as well.
The definition of cyberstalk, they included language. It states to engage in a course of conduct to communicate or cause to be communicated, and they added these words, directly or indirectly. Then it went back to the previous words, which reads as follows: words, images, or language by or through the use of electronic mail or electronic communication directed at, and then the legislature added these words, or pertaining to a specific person. And so the addition of the 6 words, directly or indirectly, and or pertaining to, clearly redefine the analysis the court must employ to evaluate these facts in light of that statutory change.
There's no doubt this judge is trying to create a name for himself in the law books with this statutory change. He's trying to create case law. And there's good news to that. There's bad news to that. Let me share the bad news first. Or George, do you want the good news? It's up to you. What do you want? Good or bad?
Hit me with the bad news.
All right, we're going to go with the bad news. The bad news is LIEnette can file for an injunction in the courts in Levy County before Judge Craig DeThomasis, and he can actually go, LIEnette says all these people, John Smith, in her spam account, John Smith, have communicated with her because of you. Therefore, I'm going to hold you accountable, and you're going to have the consequences of that. I'm going to slap an injunction on you. That's the bad news, that we can actually be held accountable for anybody else's actions in the world. You want the good news now?
Hit me with the good news.
We can go after everybody else in the world. So, for example, we can file suit against Shart, and we have no problem doing that, and find her and hold her accountable to all the consequences of anybody who's communicated with us, especially her, and because of her. We can go after LIEnette. We can go after John Crook, because we have screenshots of every piece of communication that has indirectly come, all the threats, all the negative things, all the things that have been said, and none of this has been said by a person named John Smith.
And to my understanding, and that's why I brought it to the council's attention at the time, there's been no appellate court decision addressing that matter.
On the new statute?
Correct.
Okay.
So in that context, that's one of the many reasons, along with the other things I just said, that this case is a little different than your run-of-the-mill. I handled probably 5 or 6 other injunction cases in the previous hour before I got to this one, which took 2 hours and is now clearly going to take longer than that.
There's been 3 hearings on this case so far. And just a reminder, everything I'm showing with you is public information. 3 hearings so far, roughly 2 hours for each one, 6 hours thus far. LIEnette's not even done whining, okay? So who knows how long this is going to go. We do know that she has a scheduled deposition. She's already dodged a deposition, and we'll get to that. And then John Crook has a deposition, and he's dodged that deposition. Illegally, I might add. And we'll get to that. We're not quite there yet. But we know the final hearing is January 26th. If they even can make it to the final hearing, because January 10th is the contempt of court hearing in Ohio. They very well could be arrested. And not only that, we had an incredible meeting with the Levy County Sheriff. An incredible, absolutely incredible meeting with the Levy County Sheriff. They are now in full effect going to 100%, in the words of the Levy County Sheriff Office and the state attorney, from all 4 corners of the civil protection orders in Ohio, they will enforce every word, every dot, every cross T. And they're going back to the very beginning, the very first day when we showed up at the sheriff's station and John and LIEnette stalked us there.
That being said, the court already covered the fact that I granted the continuance. It's clear to this court now that it was based on less than accurate, less than truthful representations to the court of the basis being claimed for the continuance.
It's clear to this respondent that this judge is being less than accurate, less than truthful. Let's go back, November 29th. Let's see exactly what my lawyer, who was incredible, said to the judge.
You guys want to come back on a Saturday or Sunday? I'll be here on a Saturday or Sunday. You want to come back at midnight? We'll be back at midnight. Want to come back tomorrow? Let's come back at 9 o'clock. So, are we reconvening at 9 o'clock?
That's fine. I have a doctor's
Your Honor.
appointment, but I'll cancel it.
Mr. Hales is having to address matters in Ohio court related to this situation. He has to be there tomorrow morning. He has a flight out.
I'm not sure how you get any more accurate or any more truthful than tomorrow morning he has a flight out. He has to go deal with situations concerning this matter. And I did. I went and I filed contempt of court against LIEnette and John CROOK. And on January 10th, they should be held accountable and hopefully arrested. And hopefully the consequences that follow that arrest.
And I again point that out because, Mr. Shockett, you're now advancing argument why it should be continued. Again, the court gave an admonition to prior counsel that if you've got a calendar conflict, deal with that conflict by changing whatever that other matter is or may be, because we're going to be here on December 6th at 1 o'clock.
My attorney, Attorney Feather, had a medical procedure that was scheduled months in advance. And so then I hired Attorney Shockett. And I want to share that both of these attorneys have been absolutely incredible. I can't say enough of their level of excellence, integrity, and honestly feeling a bond. Do you understand going through all this? At one point, I'll transparently share with you, at one point, I even broke down in tears, which George doesn't even know this yet, with an understanding that not only am I fighting against LIEnette, John CROOK, I'm literally fighting against Levy County, and then at the state level of the attorneys. And I was in Randy Shockett's actual office. I had to go walk to the window and walk away and just gain composure again and go, my goodness, I cannot believe how deep and how much corruption there is and why people won't just do the right thing. And these two men, not just attorneys, but these two men have stood beside us as pillars of truth and integrity. And they have encouraged us, and they've put wind in our sails, and they've laughed with us, and they've mourned with us, and
They prayed with us.
Prayed with us. I mean, I can't stress enough. I can't stress enough. Both of these attorneys, I would give them the highest recommendation that I possibly could. They've both been absolutely incredible, no matter what the judge thinks. Now, the judge, on the other hand, I'm pretty sure you already know how I feel about what he's done.
There's been an intervening development that certainly may require another reevaluation, and that is subsequent to receipt of the after-hours motion to continue that this court happened to see Monday morning when coming to work and addressing it. The court then receives what amounts to a second supplemental petition filed on December 4, 2023 at 1:04 p.m. by the petitioner, which did result in the temporary relief that was previously sought and denied at least 2, if not 3 other times.
You've heard the judge say himself, the temporary injunction was denied up to 3 times based on lack of evidence. Now, LIEnette goes and files supplemental information, says that my attorney, my first attorney, is bribing her, called her, said he would pay her off with money to make this all go away. Now, number one, I don't believe that, and nor should you. You got to understand, you can predict a person based on their patterns. You literally can predict the future. And what is LIEnette's pattern? Lie after lie after lie after lie. So what does the future hold for LIEnette? Another lie. Even if she gets arrested and she's jailed over the civil protection orders and breaking them, what do you think she's going to do? She's going to continue to disrespect them. play like they don't exist, and break them. That's her pattern. What will she do after she gets out of jail? The exact same thing. She lies about my attorney, which then this judge places a temporary injunction on me based on what she says about somebody else representing me with no proof, no evidence. He denies 3 times based on no evidence. And now he actually gives it based on what? No evidence.
That being said, and counsel is aware, and Mr. Hales, I presume, is aware, but so that he is absolutely aware, I presume, because he's had now 2 lawyers represent him, that the court has to confine its analysis of a petition accepting what's being alleged as being true, and if true, does it entitle the person for relief? The hearing then is to determine, is there competent substantial evidence, which includes truthfulness, credibility questions, etc., to be determined. So we were partway through a case where I must have said on multiple occasions at the close of the case to Mr. Feather, I've only heard one side of the case and not even the entire side of that case. I don't want to deny, I have no intention of denying the respondent ability to present contrary evidence or contradict or confront the evidence being presented against him. And so one issue, and Mr. Shockett, I just got to ask, because there's a notice of appearance that's styled as notice of appearance as co-counsel. Then there's your motion filed 12/5/23 at 12:53 p.m., styled as an urgent motion for continuance that states under subsection 2, co-counsel Mr. Feather, so that's consistent with your notice of co-counsel, is not available on 12/6. But then it adds this phrase, more importantly, respondent wishes to have undersigned counsel represent him at the continued hearing. There's a couple ways to read that. One is, he wants you and not Mr. Feather at the continued hearing, meaning today is the continued hearing, and you're here. So one way to read this is, the respondent gets that which he wants, and which, quite frankly, from the court's perspective, he deserves, his choice of counsel here at this continued hearing. But then it's a motion to continue, so I presume that when you say continued hearing, you're saying, if I continue it to the next hearing. And so that's one issue, because it would be presumptuous without any basis to be presumptuous, that I guess the court's gonna grant this continuance because we're asking for one. That would be a fallacious and strange hypothetical assumption to make without a basis, but that'd be one way to kind of look at this. But the other is, if Mr. Hales wants you at the continued hearing to the exclusion of Mr. Feather, this court will analyze this situation differently than if really you're just co-counsel to Mr. Feather. Because if you're co-counsel to him, you then have the institutional knowledge he has. You know, it's not like we get halfway through a trial or we get to the end of the trial and then somebody says, well, I've got the financial ability and wherewithal. I'm going to go hire another lawyer and say, I'm going to continue this case. I'm going to get another lawyer to start from scratch, rebuild my case, and maybe shore it up a little bit. I mean, I don't know where there's any precedent for such.
In other words, the judge is saying, Jeremy's rich. I don't understand where people get the idea that somehow I'm rich. I literally have no income, zero. I don't get anything. I hire people to help me. I rather give it to them. I give any money I make away to people in need to do things for others because that's what makes me happy and that's what satisfies me. What do I need the money for? In the long term of life, what matters is the impact you left, not what you think you're going to leave with as far as income. I don't care about the income. I care about the impact. Now, I've put a tremendous amount of money into this, and I see no end sight in how much is going to need to be invested in this. It's sad, really, because I could have an impact with other people. But if it means correcting corruption for others, so that this same thing doesn't happen to them, then it's more than worth it. And keep in mind, this is happening to me. This is happening to George. This is our life story. It is the news of our life story. And as we share it with you for educational and for entertainment purposes. Please learn from it, but don't ever communicate with those you see in it.
Process. And I don't know that necessarily that's intended, but I don't know what's intended, nor am I questioning your involvement in the case, but I got to know what your status is.
Okay, thanks, Judge. Thank you. May it please the court. My status is to continue to represent him as lead counsel in this case. That clarifies it. Here, today, if we don't finish it, whatever happens going forward, and maybe Mr. Feder withdraws, I don't know. He is at a doctor's appointment, as I understand it, in Gainesville.
Well, here's another thing, and I don't want to be insensitive about this, okay? But under the circumstances of this case, Mr. Feather didn't plead on November 29th at about 5 p.m. He said, I can be there on December 6th at 1 o'clock.
No, actually, Mr. Feather said absolutely nothing. He was talking to me, and you told him he would be there at that time, and then you adjourned. Let's go back to the video. This is why the camera is so powerful.
Be back here Wednesday, December 6th at 1 p.m. We stand adjourned.
Did any of you hear Attorney Feather agree? I sure didn't.
So if it was an emergency that came up from November 29 to today's date, medical intervention of necessity, etc., clearly the court would have waited a lot different than, oh, Judge, I've got an appointment on December 6th at 1:45 that I didn't tell you about, and it doesn't say when it was scheduled. Maybe after we scheduled this hearing, that would be ridiculously foolish to do. But I have no information to go on, and I'm not insensitive to life happening while court is happening, okay? And so if he had a medical intervention of necessity appointment, I don't know about that. I don't know that it's good cause. I ruled it was not good cause. He could have repled it. He could have asked to provide additional information. And again, his motion and yours, and we'll get to yours in a moment here, doesn't say anything about Ms. Preston's position on this. And so we've got to come here. And so I didn't deny or grant your motion. I didn't address your motion yesterday, even though I saw it yesterday, because I couldn't, because I've got to hear from the petitioner as well.
Totally understood.
And then in your motion, so you're saying that if the relief is granted and it's continued, you're going to present as lead counsel.
That's right, Judge.
Have you considered what you would do if the continuance is denied? Are you prepared to proceed today?
As best I can, given the limits, Judge. I just got hired yesterday. I had 2 hearings this morning, working within reasonable human hours. I looked at stuff last night, but woefully unprepared because in that short a time. And also, now we do have the temporary injunction in place, so there's no prejudice.
Which I said,
Yeah.
it changes things a little bit.
If you're lost in all this, let me help you get found again, okay? November 29th, judge says, with Attorney Feather's back turned to him, we will meet again December 6th at 1 p.m. and adjourns. No response whatsoever. Attorney Feathers has a medical procedure scheduled months in advance. He files for a continuance, and the judge denies it. In this time, LIEnette puts in supplemental information saying that Attorney Feathers tries to buy her off or bribe her, which then the judge puts a temporary restraining order on me and my speech and yours. And now I have to hire a new lawyer. He was hired a day before this hearing. And right now it looks like this judge is about to go, yeah, we ain't doing a continuance. How in the world is a new lawyer on the case? Because the previous lawyer has now been made a witness, not by me, by LIEnette and what she claimed falsely against him. How's a new lawyer supposed to get up to speed when she presents how many hundreds of pages? I guess that doesn't really matter. That was all thrown out as hearsay. At a bare minimum, I've got to go through lie after lie after lie after lie after lie. Listen, this could take years. This is LIEnette we're talking about.
So have you reviewed the proceedings from November 29?
Not all of them, Judge. I don't have all the materials. I've asked for a transcript. We've ordered it rush basis, so I can I do have one of those AI transcripts,
Right?
but I don't trust it because I can already see some misspellings. And as you know, the devil's always in the details, so I'm waiting for the official transcript to be prepared. And also the witnesses.
So here's the thing. I'm not I'm not asking you to disclose attorney-client communication. In fact, I'm specifically stating I don't intend to do that. That being said, so I can work on a presumption here, which is when Mr. Hales contacts you, or you contact him, whatever, when you guys come into contact with each other about this pending matter, 12/6 at 1 p.m., you either had to tell him, I can be prepared despite the fact I only have 25 hours notice, or you had to tell him, I could kind of try to be prepared, but I won't anyway near be as prepared as I could be or that I should be on your behalf. If I took your, I presume you had a conversation. I was in practice for 36 years representing people. You probably should have had a conversation. I don't want to be too presumptuous. If I get a continuance, I'll be much more prepared than I am able to do in 25 hours. And so the relevance of the question, depending on how that conversation, either Mr. Hales willfully, intentionally, purposefully hired a lawyer who he knew absolutely could not be prepared to resolve this issue today, or he hired a lawyer that he would know would not be prepared, hoping that that would be grounds to continue this, rather than go and find a lawyer who says, man, it's a short period of time, but man, I can do what I'll do, and I'll be prepared. I'll take your case. So I'm not questioning you and saying I'm not even getting into this, but I got to question the motives of Mr. Hale in gaining a continuance, because a continuance is a victory for someone who doesn't have a temporary injunction. Precluding entry of an injunction
Correct.
is in their favor, clearly.
Right.
And to the detriment of the petitioner.
But I think at some time,
I'm not sure how a continuance is a victory in this matter. He's already allowed me to be illegally served the temporary injunction. Okay, now you're going, well, hold a second. What if you're in court and the judge says, all right, you're getting an injunction, and they give you the paperwork right there? Well, that's okay, but that's not what happened. Remember, LIEnette filed paperwork, supplemental information is what he's been calling it. Then he issues a temporary injunction. Now, Levy County Sheriff and the courts are trying to serve me. I'm not even in town. I'm in Tampa. I don't have any information. They cannot legally serve me in the courts in Florida. And yet that's exactly what this judge allowed to be happen. And he will even reference it during this hearing.
well, first of all, there's more that happened in the meeting that I'm not allowed to
Well,
reveal.
I don't want you to. I don't
Well,
want
yeah.
you unless you guys are willing to waive. I'm not saying that. So that's what I'm saying. You either, and I'm not saying that you were completely negligent in not telling your client, dude, you know you're hiring me and the hearing's 25 hours from now. How can I possibly be prepared? Or you said, I'm on the spot. I got it. I do this all the time. Whatever. It only implicates Mr. Hale's decision to retain a lawyer who now is in front of a court saying, I cannot effectively, as competent as I want to be, represent his interests. You're saying I'll do the best I can, and I know you will, but you're not saying I'm going to provide him effective representation. Now, there's no constitutional requirement of effective representation when it's counsel of your choice, and you knowingly hire somebody who tells you they can't be fully prepared. Or it might be that you hire somebody who can't be so that you shore up your argument to continue it.
Okay. So, first of all, we have the protection in place here of the TO. We have that. And that did come to my attention yesterday. I think it posted online like within an hour after I filed the motion. I knew that this was relevant in weighing the prejudice to both sides. And I can tell you as an officer of the court that this is not a case of just continuing counsels and I'll be the lead counsel in this case. And so I think there's very legitimate grounds, given what we have here with this helps tip the scales of given this lack
Let
of.
me ask you another question. How do you plead under subsection 4 that the petitioner will not suffer any prejudice or inconvenience as a result of a continuance? How do you?
Well, it's a brief continuance, Judge. I don't think it's going to be any prejudice, and now.
Well, what's brief? Because that's
Well,
another
that's
thing. The
when's
motion
our court.
doesn't
I'll do
ask-
this.
The motion doesn't ask for a particular period of time.
I don't have your. Well, I would say as soon as you want. I mean, within reason. Give me 10 days to get prepared, and we'll be here in 10
Well,
days.
you know, I've been tempted to do this in the past, not with you, but with counsel that moves for continuance, but doesn't say how long. And I could have continued it from 1 o'clock to 1:30.
Oh, right, yeah.
I mean, I don't know how
Yeah.
long you need.
Yeah, right.
Right?
You want 20 days, I'll give you 20 minutes, right, yeah.
So, to say that there would be no prejudice or inconvenience, I mean, we know at a minimum the inconvenience is the petition was here on the 29th, agreed to be here on the 30th despite the fact that she would reschedule her doctor's appointment, then agreed if it accommodates them, and Judge, you're saying we can do it on the 6th, I'll be here on the 6th, she's here on the 6th, so there's some inconvenience.
This judge seems to know a lot about LIEnette's travel schedule, especially after he has clearly stated that LIEnette has confessed she's paralyzed to her property. And yet this is the same woman who wants to run for town council. Wait, you mean you're not paralyzed? Who shows up at the post office, looks George directly in the eyes after parking next to her car, stands out in front of the post office, has another conversation with Dan Shannon of Otter Creek. Paralyzed? Wait, this is the same person that follows us to the sheriff's station. Paralyzed? The list goes on and on. Doctor's appointments. She goes to Naples. Oh boy, wait till you hear about Mama Rasputin. Oh, but don't worry, it's a miracle. It is a miracle. Mama Rasputin never dies. That joke will make sense later, I promise.
And she'll have to come back again. I don't think that you filed this pleading when there was a temporary injunction in place.
I don't know, what time was it?
Your filing is at 12:53 p.m.
On the 5th or the 4th?
On the 5th.
Well, this was filed on the 4th, Judge. Wasn't this order entered on the 4th? Or the 5th? I don't even know now. Let's see. Entered on the 4th. This TRO.
And so your position is that if the court has the temporary in place, there's no prejudice because she's got the protection that she's seeking temporarily.
Yeah, and you can continue there's a day, 15 days, I think, you can continue that if it gets continued. But yeah, the protections are in place.
With regards to inconvenience, why is it not inconvenient for her to have to come back?
She's won, Judge. She's won. She has her injunction.
Well, no, she's asking for a final, at the start of the
understand.
proceedings, I ask all petitioners, are you here asking for a final judgment?
Right. Which would adopt the same standards, the same restrictions against him. Just a question of how long it's for.
Well, it's not, and I guess that's going to get us to another issue, which we'll get to in a minute, which is if there's a temporary injunctive relief in place, it's going to have to include additional language than the general buffer zone language.
Okay.
And we can address that here in a second, but I guess you're not able to disclose to this court whether Mr. Hales intentionally, willfully retained counsel that could not be prepared.
There were other issues we discussed. I really don't feel, I'd like to say it, but I can't.
Okay, if you can't, that's fine.
It's more than just that.
There's at least the appearance of manipulation of the court to continue it, to either allow continued behaviors that are intended, to allow what came out in evidence was a financial incentive to continue certain behaviors, because it came out in evidence on November 29 that Mr. Hales makes a financial profit from the actions that Ms. Preston is claiming are causing her substantial emotional distress.
Why does LIEnette keep saying I make buku bucks off of her? I've never made a single penny off of LIEnette. As a matter of fact, it's obvious that LIEnette's never even made a single penny off of LIEnette. If I was making so much money off of LIEnette, could you imagine how much money LIEnette could make off of LIEnette? But she doesn't? No. The only way I make money is here. It's Jeremy Hale's brain. It's what I think and what I do. It's me who makes money for me. Has nothing to do with LIEnette whatsoever. And any money I make goes to pay bills, employees, and to help people advance and further their lives. And if I wanted to make buku money off of LIEnette, why did I issue a cease and desist on May 23rd, 2023, before any video was even out there? By the way, it was her who was videoing town hall. It was her that was videoing and saying all these things and setting up signs all over town. If I was out to make buku money off of LIEnette, why have I spent buku money to stop her and to try and protect people from her, particularly myself and George and the precious people of Otter Creek, not to mention the child and animals that are being neglected and abused as well? If I was out to make money, I would want it to keep going on and on and on. Now, LIEnette's saying that I'm trying to take her property and kick her out of town. If I was out to make money, buku money off of LIEnette, I'd want to keep her here in town to keep making that money. This argument is complete and total foolishness.
She's met that burden, which is a higher burden without evidence here. And, you know, she's basically.
Right, but what I'm saying is, on this point, is that the continuance could be to the benefit of Mr. Hales, while it's to the detriment of Ms. Preston.
I just.
Because he's earning a living.
But he's prohibited from doing the acts that cause harm,
Well,
so.
that's the part we need to be clear about.
Okay, let's
In
be
the
clear about
temporary
it.
injunction.
Yeah, sure.
Because I don't think the temporary standard injunction that was previously ordered necessarily includes that.
The judge is referring to me making videos, which, remember, YouTube is the biggest news platform in the world. And everything I film is legal. Public information. I'm showing you the court records right now. And in one of LIEnette's motions, she said, Mr. Hales has a camera in his shirt and he's hiding it and he's filming the court proceedings. I'm not sure how I got 3 different angles from one camera in my shirt, but hey, look at me. Apparently I can do anything and the world works for me, right? No, obviously not. It's all public information that I share with you. And she's made herself a public figure. At a bare minimum, 10 different Facebook pages, hundreds, if not thousands, of begging GoFundMes. And it goes on and on. She's worked with all of government in Northport. She wants to be a part of government in Otter Creek. She is, by the very nature of what she has said and done, a public figure. It's public information. And everything I film is legal. And everything I say is legal as well.
And let me share with you something else, Mr. Shaka.
Okay.
And again, this is I presume, outside of your control.
Go ahead.
Which is part of what's pled in the second supplemental petition filed December.
I did see that supplemental petition.
Yeah, is that Hale's attorney, which is referencing Mr. Feather, has called making multiple offers of cash or proceeds from Mr. Hale's videos, or telling his fans to leave me alone.
Twice now.
And hang on. And I say that
Do you really think I would ever give this woman 1 penny? That's the issue that she has blown up from the first place, because we refuse to allow her to get any money from us or others or from our following. But the reality is there are those who have followed us that have given her money and have given them gifts in kind, physical items and cash, whether it be cameras, whether it be gifts for Christmas. The reality is she has benefited. But do you think I'm going to offer her any money? No, I'm not going to offer her any money. There is no money I will ever offer her. I won't even offer her money for her current dump. I don't want the dump. Now, I do believe I'm going to get it, but that's besides the point. I would never offer her any money whatsoever. This is a pathological liar stricken down with liabetes. That's why you hear that scratchy voice. That's a symptom of liabetes. And here she is, LIEnette at her prime, lying about my attorney Feather.
ma'am, I have to accept the words that you've pled as true. We're going to get to an evidentiary hearing
Okay.
about whether there's more or whatever, but that's what's pled.
Sorry.
And that's especially relevant because it was Mr. Feather, when I suggested that, hey, this can't, at 4:44, 4:47, when I said, this is not likely to finish here today, and he pushed back and I said, denied, it's being continued. There's good news and bad news. Bad news, you're gonna all have to come back. The not so bad news, I don't know if that's good, is maybe counsel for the respondent and the petitioner can communicate about working towards a resolution. And I said that in the context, and I kind of regret saying it, quite frankly.
I bet that's not the only thing he regrets saying, understanding that this is all public information, this hearing and all the ones that follow.
But I said it in the context of, I've presided over hundreds, maybe thousands of these similar cases. And there are people, just like every other civil case, that can work towards a resolution. Clearly, Mr. Hales and Ms. Preston should not be the two people. And so I suggested maybe counsel can speak to, and it was Mr. Feather that said to the court, and hang on, I'll just quote, that the language in the Ohio injunction that was already in place would not allow for such communication, and that in fact, from his perspective, Ohio's law would consider it a violation.
And that is true. She is not allowed to communicate with me or George, nor is John Crook allowed to communicate with me or George directly or indirectly through any other third party, including we just lost power.
We just lost power.
Whoa. A lawyer.
And I said, well, I don't understand that. I said, show me. He handed me a copy of the final judgment from Ohio. I read it and I said, I don't see here where contact between an attorney for the respondent having communication, working towards a resolution of a potential litigation in another matter, somewhat related, but another matter, would be a violation of Ms. Preston violating the terms of that Ohio.
Frankly, I'm shocked that he's lost in this process by any third party. There's not an exception to say, oh, you're in a trial and an attorney is going to talk to you and then you're going to talk to Jeremy through the attorney. It's any. That means all. There is no communication through any third party. There is no exception. And by the way, LIEnette has done a tremendous amount of things wrong, and she is a pathological liar, and she has mental illness. There is no doubt whatsoever, in my opinion, and I'm sure in her doctor's opinion, which we're going to try and prove in court as well. But the one thing she didn't do, there was no communication from her to my lawyer to me. There was no third-party communication. I got nothing.
But that was the position taken by Mr. Feather. And I didn't absolve him of that. I didn't resolve that issue. I didn't give him any clear carte blanche. No, dude, it's cool. In fact, what I said to him is I said, if you need clarification on that so that it's not a violation from either perspective here, I'll call the judge in Ohio and we can always carve out an exception. I do it all the time with my colleagues in the criminal court. They have no contact, and then I have the same people in a divorce case.
You know, this judge keeps saying he's going to contact everybody in Ohio, from the judge in Ohio to my lawyer in Ohio, when he says I didn't provide sufficient evidence. And guess who he's contacted so far in Ohio? That's right, no one. Remember, he spent 2 months just trying to get me documentation that he can get to anyone, anywhere, all over the planet. And he never even got it to me.
Judge, can you modify that language to allow them to attend mediation with a mediator and their lawyers present? We'll do it by Zoom. We work out those deals all the time.
But interstate, you've done it interstate as well?
Yeah.
Okay.
I am confident Judge Greg DeThomasis just lied to my attorney. I've seen that I've seen it before. You remember? With Mary, when I caught her in a lie. Am I the only one in town with a 2-inch meter?
There's one other.
Who's the other?
Well,
the judge, now being caught in his lie, as my lawyer asked him a question, is going to start pointing fingers back to my first attorney. This is called deflection.
Feather was the one that pointed out 741 hang on, don't hold me to it, but 135 or whatever. I've got jurisdiction. There's full faith and credit for their order.
Yes.
He actually said, and this is another thing contradicting, and I'm saying, Mr. Hales, I'm not saying you're contradicting what I'm about to say here, but your lawyer did, which is, the lawyer was representing to me, Mr. Hales had to go up there to do something. I now know it's about dealing with some alleged violation, what have you. Feather was here in court saying, Judge, we anticipate. The word wasn't anticipate. I can pull up the exact word, but it was about we anticipate, we expect, something to that effect, don't hold me to it, I don't have the transcript in front of me, the filing of a violation here in your court for Ms. Preston allegedly violating. I go, why would you be filing that here? And he brings up the statute and says, because we can. And I didn't contradict that. Okay, if and when you do so, we'll cross that bridge when we get to it, but we're not there yet. You anticipate it, you expect to do so, whatever, you haven't done so yet.
I think they did it today, Judge. I think they did it today.
Yeah, but it's Feather who says to me, this premise of speaking to Ms. Preston would be violating a court order from a judge and or magistrate in the state of Ohio. And then I get an allegation that I have to accept as true. It may not be ultimately when we get to an evidentiary hearing, but I have to accept it as true that he's contacted her and on multiple occasions offers her cash to drop this or to some way settle this. And that, on top of everything else I've already talked about exhaustively here, is very troubling. And has to be considered when we're considering continuing this thing even again. There is at least on the face of what's pled, and I know you're restricted in maybe not being able to say more, that there's a possibility that the motion to continue is manipulative at best. That being said, I've already said we could probably come up with conditions in addition to the general ones of the temporary that would satisfy this court, allow for Mr. Hales to have fully effective representation because of attaining a fully prepared lawyer, and giving Ms. Preston peace of mind between now and then, even if it's at the cost of what I consider slight, but still some measure of inconvenience of having to come back, but everybody would have to come back.
Issue number one, LIEnette Preston will never have peace of mind because she has a very troubled mind. Issue number two, the judge does go on to amend a normal injunction, and he clearly, purposefully takes away my freedom of speech, my First Amendment right, and not only mine, all of yours, and that's huge. And then he takes away my legal right to all of my property, completely and totally illegal. And in hearing number three, you'll hear me say it to his face. He illegally took away my rights.